Hello candidates. So I hope your mains examination went well and we are having the discussion for paper 2. Many candidates have approached us regarding the factual questions that have been asked. So the paper may seem very direct, but the paper was not easy because the things that are asked, few questions are very simple, but the few questions were simple but had some add-ons. For example, the comparison with the United States or the inclusion of the questions specifically with respect to the Jammu and Kashmir Reorganization Act. So I'll be discussing two questions that are from the executive. These questions were very easy and still we'll see how we have to approach for these questions. Okay. The first question is compare and contrast the president's power to pardon in India and the USA. So they are asking the similarities as well as the differences. Are there any limits to it in both the countries, and what are preemptive pardons? It means this question has three parts. First, they are asking what are the powers of the Indian president and the US president with respect to the pardon. Second, they are asking for the limitations. These we can do it in a comparative form. Whenever there is a question regarding this, it's always good to have a comparative analysis so that it is easy for you as well as for the examiner to read the answers very clearly. And with the comparison, at last we'll also discuss what are preemptive pardons. Okay. Now here we'll discuss the pardoning power of President of India, and here we'll discuss the pardoning power of the President of the USA. Now let me give you the context why this question was asked. The former President of the USA, Mr. Biden, he pardoned his son Hunter Biden, and also he was looking for the options for giving preemptive pardon to his vice president, then Vice President Kamala Harris, and the other members of the cabinet that are called as the spoils system, the part of the secretaries of the cabinet of the US president, so that the new president does not start any cases against them. So preemptive pardon was in news. The pardoning of the USA president was in news. That is why they have asked this question. Okay. So it was not that they have asked it very abruptly. It was too much in news in the month of December. Okay. Now the President of India, their pardoning powers are mentioned in the article 72. The pardoning power of the US president is in the article 2. Okay. So both are the constitutional powers of the respective presidents. The pardoning power of the President of India is not the discretion. This is not the discretion of the Indian president, and it is on the basis of the advice of Council of Ministers. The pardoning power of the President of the USA is the discretion. Okay. The President of India can grant pardon after the judicial process is over and it's independent of judiciary. Independent of judiciary. It means it is a power of the president, but it is not in combination with the powers of the judiciary in the country. They both are independent. Here, the president may even grant pardon during the judicial process. During the judicial process. Okay. Now, in addition to this, the President of India can grant pardon for A, violation of union laws. B, in case of a death sentence. And third, in case of a military judgment. The US president can only grant pardon for the violation of federal laws. Federal laws means, in short, the violation of the union laws of the USA. When it comes to the state laws of the USA, the US president does not have any such power. Now, the powers of the Indian president, they are under partial judicial review. You can also give the judgment related to it, that is the Ipru Sudhakar case. See, for the candidates, the question is tough for the USA comparison, but it is not tough for the Indian president. So write whatever you know about it clearly, right? Ipru Sudhakar case 2006. Here it is out of judicial review. It is out of judicial review. It means there is no need to have a participation of the government's role from the judiciary. There is no participation. Even Congress, the US Congress, have no role. Okay, there is no role. It's totally the personal decision of the president. In India, pardon absolves from all convictions. Here both conviction and pardon is recorded. Okay, it means a person was convicted, it will be remembered in history. The person was given pardon, it will be remembered in history. In India, it is set free. Now, what are the limitations? So limitations, if we say US president, first limitation, only federal laws. Second limitation, there cannot be any pardon, no pardon in impeachment cases. Impeachment cases. And third, that in the USA, even though there is preemptive pardon, but the pardon cannot be given before the commitment of a crime. There is no anticipatory pardon that this person will do a crime in future and this person is now given pardon. Pardon cannot be given before the crime was committed. Okay. Now, the last part of the question is preemptive pardon. Okay. So, preemptive pardon means that the person may be given pardon before beginning of judicial process. Beginning of judicial process. During judicial process. After conviction also. Okay. It means if you see, this is the preemptive pardon. That the person is still not convicted, but still the pardon was given. But preemptive pardon can only be given when the crime was committed. So from the commitment of crime till the conviction, if the pardon is given, it is called as a preemptive pardon. In India, there is no preemptive pardon. In India, pardon will only be given when a person is convicted and sentenced. Okay, so this was the first question. It was an easy question, especially if you have to just write about the pardoning powers of the president, right? Then comes the second question. Again, it is a repeated question. The UPSC has asked this question, but previously they have asked it in 250 words. This time they have asked it in 150 words. The role of Attorney General of India in guiding the legal framework of the Union government and ensuring sound governance through legal counsel. So this is not the question, this is a statement. You do not need to elaborate the statement that what is the legal framework, what is the work of Union government, what is the governance. The question is, discuss responsibilities, rights and limitations. The question is, discuss the responsibilities, rights and limitations of the Attorney General. So we have to start the question with Article 76 provides for the office of AG, which is a constitutional post. Constitutional post as the first legal officer of Government of India. Attorney General is a person who is appointed by President if that person is qualified to be a Supreme Court judge. The person's responsibilities are majorly three. The responsibilities are, first, to represent Government of India in courts. Second, to represent on behalf of President under Article 143, that is the reference that is sought from the Supreme Court. And third, any such functions that the President asks the Attorney General to perform. These are the three responsibilities. It means any function as provided by the President to perform. Now, what are their rights? First right is audience in any matter of Government of India. If there is any matter against the Government of India, the Attorney General has the right to have the audience of that case. Second, under Article 88 can sit, speak and be a part of proceedings and committees of Parliament. And then there are the limitations. So what are the limitations? It's very simple, that you will include it, that the person rights also we will include. They have right to practice privately. Then we will start the limitations from here only, but there are limitations. First, cannot take case against Government of India. Second, not representing an accused in a criminal case without permission. Third, not be appointed as a director without permission. There is a fourth limitation, cannot vote in any House of Parliament because they are not a member. The other challenges or the limitations at the office of the Attorney General is that Attorney General's all terms and conditions are only decided by the president. They don't have a security of tenure. They don't have any fixed salary and allowances. They only have their terms and conditions as decided by the president. Because it is just a 10 marker question, so you don't need to mention about the supporting or staff that is provided in the form of the Law Officers Act, that is the Solicitor General and the Additional Solicitor General. So the questions were direct, but still, because the time limit is very less, so including all these things in an answer will be the best answer. But if you have written an answer even close to those lines, it will be a good attempt for these two questions that are asked from polity. I believe that the discussion had been fruitful for you, and we hope that you have written that was discussed in the session. Thank you very much and all the best.